And this is People of the State of Michigan versus Delvante Coleman, docket number 20-903 FH. And I'm told this is a plea today. What counter counts is it a plea to, Ms. Allen?
Count one, Your Honor.
Count one, okay. Mr. Coleman, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes,
Thank you. Mr. Coleman, you can put your hand down. You have the right to an attorney. You are represented by Mr. Hess. And Mr. Hess, this is a plea to count one, correct?
Yes, Your Honor.
And you'll waive reading of counts 2 and 3?
Yes, Your Honor.
Ms. Allen, would you read count one, please?
In the People of the State of Michigan versus Delvante Coleman, filed 20-903-FH, State of Michigan, County of Ingham. In the name of the people of the State of Michigan, the prosecuting attorney for this county appears before the court, informs the court that on October 31st, 2020, at 2700 Eaton Rapids Road, Lot 299, Ingham County, the defendant did in count one commit the offense of aggravated stalking, that he did engage in a willful course of conduct involving repeated or continuous harassment of Tiara Taylor, the conduct being such that would cause a reasonable person to feel terrorized or frightened or intimidated or threatened or harassed, said conduct actually causing Tiara Taylor to feel terrorized or frightened or intimidated or threatened or harassed, and the course of conduct included the making of one or more credible threats against Tiara Taylor, contrary to Michigan law. This is a felony punishable by up to 5 years and or $10,000, probation for any term of years, but not less than 5 years, and was committed against the peace and dignity of the state of Michigan.
Mr. Coleman, you're being charged here with what's known as aggravated stalking. That is a felony punishable by up to 5 years in prison. Have you had enough time to talk about the charge with your lawyer?
yes, Your Honor.
Do you understand the charge against you?
Yes,
I forgot to say also, punishable by up to 5 years in prison, and also if you were on parole at the time, it would be a mandatory consecutive sentence. Okay, you said you've had enough time to talk about the charge with your attorney, and do you understand the charge against you? I think you said yes.
yes.
Do you have any questions about what we're doing?
No, ma'am.
How do you want to plead?
I would like to enter a guilty plea.
Okay, if your plea of guilty is accepted by this court, it means you won't have a trial of any kind, and you'll be giving up the rights that go along with a trial. I'm going to go through those with you. It means you'll give up the right to a trial by jury. If you didn't want trial by jury, trial by judge. You'll give up your right to be presumed innocent until proven guilty, and your right to require the prosecutor to prove your guilt beyond a reasonable doubt. You'll give up your right to have the witnesses against you appear at the trial and to be able to cross-examine them. You'll give up your right to have this court order any witnesses that you might have to appear at the trial. Also, you're giving up your right to remain silent at trial and not to have that silence used against you, or in the alternative, to testify at the trial if you wanted to testify. Also, there are two things that are different about appeals when you plead guilty. One is that you don't get an automatic right to appeal your case to the higher court. Instead, you have to ask them to hear it. They have to agree to hear it. And the other is there are many issues that you cannot appeal when you plead guilty. Unlike people who go to trial, if they get convicted, they can appeal pretty much everything. Do you understand those rights?
Yes, Your Honor.
And Mr. Coleman, also, if I accept your plea, it means you cannot come back later on and try to say that the plea was the result of some promise or threat that no one told me about today. Do you understand that?
Yes,
It also means that you cannot come back later and try to say that it really wasn't your own choice to plead guilty today. Do you understand that?
yes,
Is there a plea agreement, Ms. Allen?
There is, Your Honor. In exchange for the defendant's successful plea and sentence to count one, the people agree to dismiss count two and count three. There's also a sentencing agreement pursuant to People versus Killebrew that the defendant's upfront jail will not exceed 9 months in the Ingham County Jail, and he does agree to serve the 5 years of probation as required with this conviction. Thank you.
Is that a full and complete statement, Mr. Hess?
It is, Your Honor. Thank you.
And Mr. Coleman, is that your understanding of the agreement as well?
Yes, Your Honor.
Do you agree with it?
Yes, Your Honor.
There's an agreement about your sentence that it would be no more than 9 months in jail up front. If for some reason I decided not to go along with that, I would tell you before I sentenced you, and I'd give you a chance if you wanted to take back your plea and start all over. You got all that?
Yes, Your Honor.
Has anyone promised you anything else in order to get you to plead guilty that hasn't been said here right now?
No, Your Honor.
Anyone used any threats?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
And are you doing it because you believe you are in fact guilty of this offense?
Yes, Your Honor.
Okay, so tell me about what you did to Tiara Taylor, and this is on or about October 31.
I did show up to a family member's house where she was without her knowing. And
Okay. Were you harassing her?
I was.
Were you making repeated contact with her?
Yes, I did.
Why? What were you doing or saying?
At the time, it was during a breakup time. I had taken the breakup pretty badly. I started drinking a lot, and though I was intoxicated, I still had control over what I could have done, but I just went about it the wrong way.
Okay, I understand. Did you make threats towards her, like you're gonna kill her or you're gonna do things to her?
I did make threats towards her.
Okay, and you went to her house more than once, is that right?
Yes, I showed up 2 times that night. Yes, Your Honor.
And you did damage to her house and her things in the house?
No, Your Honor. I showed up 2 times to the. They said I tried to go into the door, but like I said, I was intoxicated. I don't recall.
I know, but you did damage to some things in her house, correct?
I don't recall, Your Honor. I don't believe so.
Okay, but in any event, on 2 occasions, you went to her house and she didn't want you there, and you made at least 1 threat against her. Is that correct?
Yes, Your Honor. I showed up to her cousin's place. It was a family member's place.
Yeah. Okay. And I find that well, let me ask you, did you say that you would finish her?
I sent a lot of text messages while I was intoxicated, Your Honor. I'm sure I probably said a lot of different things. Yes.
Okay, then I find that this statement actually would cause someone to feel terrorized, frightened, or intimidated, or threatened, or harassed, and that it would have caused Tiara Taylor to feel terrorized, frightened, intimidated, threatened, or harassed. And these events happened on Eaton Rapids Road in Ingham County, state of Michigan. Is that correct, Mr. Coleman?
Yes.
Okay. Has the court complied with MCR 6.302, Ms. Allen?
And yes, Your Honor, and can I just add one more thing on the record? Because I understand Mr. Coleman says he doesn't remember some of it, but there's a significant amount of restitution. So I just want to put as part of his agreement that he's agreeing to pay restitution, and we discuss the amounts, at the pre-sentence investigation report, but for things that may have been damaged and things even he doesn't recall.
Yes. Okay. Is that correct, Mr. Hess?
Well, restitution is required by law, so I don't think there's much we can do about that one way or the other. We'll await the prosecution's damage estimate, and I'll go over that with Mr. Coleman.
All right. Has the court complied with MCR 6.302, Mr. Hess?
It has, Your Honor. Thank you.
Are you aware of any promises, threats, or inducements other than those already placed on the record, Ms. Allen?
No, Your Honor.
Mr. Hess?
I'm not, Your Honor.
The court finds the plea is understandingly, voluntarily, and knowingly made without undue influence, threats, or promises of leniency. It is an accurate plea. It's supported by the testimony. The plea is accepted. Sentencing is Monday, April 5th at 3:15? And Mr. Coleman, I'll ask you again at sentencing, but do you agree that it's okay if we sentence you remotely from the jail, just like we did this plea today?
Yes, Your Honor.
Thank you very much. Then I'll see you back on Zoom on April 5th at 3:15. And you should just know that someone from the probation department is going to have, I think, a virtual interview with you, a remote interview with you in order to get information from you that goes into the report that I use for sentencing. So it's really important, and you can expect that to happen pretty soon. Okay, do you have any questions? Do you have any questions, Mr. Coleman?
No, Your Honor.
Okay, then you are all set. You can tell them at the jail that you're all done.
All right, have a good day.